landlords and tenants when getting information and vetting prospective tenants. So please feel free to check that out on our website, and I hope that might be useful to you. So I'll hand over now to Caroline. Oh, thanks very much.
Cool, so thank you for coming along, and we'll get cracking. So it's really important for a lot of you, what does GDPR mean to New Zealand? We all know what it means, or some of us know what it means to Europe, but what's its actual impact here in New Zealand? So before we get started, first of all, a bit of stuff about what is GDPR. It's a word we all hear, but what does it actually mean? So GDPR came about, it is the General Data Protection Regulation. So it is a European law that covers all EU countries. It went in May last year to replace the previous previous directive. So the directives meant that each European country used to have to put them into their own member state law. So the problem with the directive was that each country put it in slightly different. So we had multi-visions of the same theme. So what they did was they made it this time a regulation, so we didn't have a multitude of variations. That said though, each country is still allowed to pick some bits of it for themselves, because that just makes it interesting. So things that each country are allowed to pick in their own member state law is things like what age someone becomes an adult under GDPR. Different things apply depending on whether they're an adult or child, but when do they become an adult? Also, individual countries can require things like their data protection officers to pass exams, have certain qualifications, etc. And each country can pick those for themselves. So there is some flex, but the idea of it was to unify how people's privacy was treated across Europe. The other key driver for it was to become more transparent and expand individuals' rights for it. Now, common misconception, it came into effect May last year. There was a grace period of 2 years, so you could prepare for it. That 2 years finished last May. So you have missed that grace period. As of today, it is in effect. There is no, oops, I didn't know about it. It doesn't, I can have another 2 years to prepare for it. In terms of it, the GDPR, a lot of it is risk-driven. So things like you have to put in appropriate controls to what data you process and your organisation. So it is not a one-size-fits-all for solutions under it. Now, one of the things that a lot of people expect is the fines. So, unlike New Zealand Privacy Act at the moment, under GDPR you can be fined. So the fines for non-compliance with it can range up to 4% of your annual turnover, and that's your worldwide company's annual turnover, not your profit, your turnover, or 20 million euros, whichever is the bigger of the two numbers. So if you're Google, that's a hell of a bill you're going to be getting. That said, the regulators in Europe have been very clear that only using fines for people who are systematically non-compliant. So that is, you have received your invitation to comply. You've received your letter saying please sort yourself out, and you have chosen to completely ignore it. So, their idea is to encourage compliance, not, persecute for lack of it. The other thing about the fines, if you impact on an individual, as well as the fine to the regulator, you may have to also pay a fine to each individual you have impacted as well. So that 20 million euro may not be the top of your bill. You may have more. So, who's covered by GDPR? So, first of all, exactly the same as the New Zealand Privacy Act. You have to be living to be covered by the GDPR, first of all. The other thing is, you have to be living in Europe. So, you have to be in Europe at the time you want to be covered by it. So, if you live in London and come here on your holiday, the minute you are here on our soil, you are not covered by it. You are covered by our act. You're here. So, you need to be in Europe, sitting there. Or, you need to be an organisation which has got an establishment in Europe. So if you're a company operating in France, even if all your clients are New Zealanders, you still are covered by GDPR. So you might come under one or both of those. And the same is if New Zealand citizens go to Europe and they're there in Europe, they are covered by the GDPR. So you can go over on your holiday and enact your rights under GDPR there, if that's what you so decide. However, as soon as you leave Europe, no. So, types of organisations that cover it. So GDPR has some extraterritorial scope to it. So it can cover outside of Europe, and we'll come on to that shortly. But there are two kinds of organisations under GDPR. There is what's called a controller. So that is a company, organisation, charity, etc., who decides what is going on. So they decide what information to collect, how it's going to be collected, how they want it processed, for what purpose, etc., when it's going to get rid of. They are the one who is ultimately responsible for that data. We then have the role of a processor. So the processor is another organisation that does something on a controller's behalf. So they do exactly what they were told to do. So it might be a service provider, so like Microsoft, who host your application because you asked them and you signed a contract to take hosting from them. It might be an outsourced provider who does your payroll for you, for example. But they are doing what you told them as a controller to do with that information. And the responsibilities of the two different parties are quite different, and we'll come on to that in a bit. We're saying, though, an individual organisation could be a controller and a processor. So particularly in Wellington, we've got quite a number of SaaS providers here, software as a service, who are controllers for their own operations, and they also are a processor for their customers. So if you are in those organisations, just being clear which data, which bits of your process and your organisation are under which piece of that role. So, for the controllers that are in scope, so we said it's got extraterritorial scope to it. For New Zealand, that means that you have to be doing something there. In terms of, you may have staff in Europe. So even if it's one staff, it's a contractor. If they're in Europe, then you become a controller for it. Or you are tracking the behaviours of Europeans. So have you got your Google Analytics on an identified model, etc.? Or did you process your data in Europe? So did you decide to use Microsoft Azure and you didn't put the geofencing on? So you're now hosting in Microsoft Germany. Okay, you have pulled yourself in scope. Some of the easiest ways of avoiding being in scope is to actually just turn some options off so that you don't get there. In terms of the other one, it's all about, are you targeting Europe? So, if I'm a bookshop here, and I get a customer from Europe, come on my website, so they've searched all over Google, found my website, come on here and ordered their book and had it shipped to them. I'm not in scope as a controller. But if I have, as the bookshop owner, advertised my services in magazines in Europe, for example, or I have started taking payments in euros, or marketed in German, etc., I am obviously trying to entice Europeans to do business with me. I'm making it really clear I want them as my customer. I'm encouraging them to come here. That is enough to bring you in scope as a controller. Now, in terms of processes, these are really hard. So you are a processor. If you are a processor in New Zealand, the first you may know about it is one of your controllers, one of your customers, contacts you with a new contract or a data processing agreement and says, hey, I want you to comply. So you need to have done nothing, and one of your customers may bring you in scope as a processor. So we had a lot of people in New Zealand who suddenly got that in beginning of May last year. Suddenly realised, oh dear, I've got customers in Europe who I didn't even know about. Or customers in New Zealand who are controllers in their own right. So people who provide services to Air New Zealand, for example, suddenly became potentially in scope as a processor. So, you know, quite a few people got that sudden wake-up call. So, in terms of compliance, GDPR has principles to it. It has the main 6 principles: lawfulness, fairness and transparency. So these, you'll see, are very similar to New Zealand. In fact, they're all the same as New Zealand. So if you were doing best practice New Zealand compliance, the actual uplift for GDPR is not very great. That said, if you are barely making compliance for New Zealand, or not making it, then you've got quite a way to go for your GDPR stuff. But if you are doing that best practice, there is not that far. So let's say, the main principles are the same as in the New Zealand Act. But, of course, there are some key differences. So, first one is the actual definition of personal information, or personal data as they call it. That is wider than the New Zealand definition. So, even if you have a pseudonymised data set, which wouldn't normally be covered here, if it can be re-identified with either your own information or another organisation's information, then it is covered. So, you know, we've got a lot of us around here who've got, you know, synonymised or anonymised for their belief, but actually if I match it up with some other government departments, etc. around, I will know who every line item is in it. So, if you are dealing with GDPR, just think about that width of it when thinking about what your information is covered. The other changes you would have seen that were quite visible was around consent. So, under New Zealand, we don't have particular guiding principles for that. We have best practice, however, and say, best practice, you'll be there. Under GDPR, the consent has to be freely given and actually shown to be an active process. So that is why you are now seeing things like the cookie pop-ups appear on every website. That is them asking you, getting your consent to add things to your device, to get information off your device. So it's no longer enough to say, I've got a privacy policy or notice, and if you go there and read it, that's fine. If you don't, well, that doesn't matter. I can just carry on and do what I want. Under GDPR, if you are relying on consent to process information, you actually be able to demonstrate someone actually agreed to it. They didn't sit silent, they actually made a step for it. So again, but that is best practice for New Zealand. Transparency. Actually, you know, respecting what the customer wants to do, rather than hiding it away. So again, nothing new there. So, there are some key roles under GDPR. So, under New Zealand law, we're all meant to have a privacy officer within our organisation. If you are covered by GDPR, either as a controller or as a processor, you are required from New Zealand to have an EU representative. Now, that is your legal mailbox, in effect. So, that is someone who has to be in Europe, and they are responsible for your fines if you forget to pay them and disappear. So they don't need to be your employee, you can buy them as a service, etc. But you have to have one. Okay? So you can work out which one you work, so you can share them with other organisations, etc. But you need to have that contact person in Europe. We then get on to what's called a data protection officer. So depending on your organisation, you may or may not need a data protection officer. So if you are a controller or a processor, and you process large-scale holdings of personal information, then you are required to have a data protection officer. Now, slight drawbacks of this is they have not defined in the legislation what large-scale means. But also consider, just because you are large-scale for New Zealand, how big are you in the European market? How, you know, comparative to European companies, are you actually as big as you think you are? So, before you decide you are a large-scale processor. Some of the main ones we see from New Zealand are those SaaS providers who are processing a lot, the Xeros of this world, etc. Absolutely. They're processing large scale across the place. If you have a data protection officer, they have certain requirements for it. So they have to report to the highest level in your organisation. You also can't interfere in them doing their job, and you can't fire them for doing their job either. And you have to give them appropriate training and support within your organisation to do their job. So they've got quite a lot more rights, etc., and requirements around them than the New Zealand Privacy Officer. If you do have a data protection officer and your EU representative, you have to provide their details on your privacy notice that you make available. So those details need to be included at the bottom underneath your New Zealand one there as well. It can be the same contact details, but you need to have them there. In terms of PIA, so mandatory PIA. So in New Zealand, it's best practice to do your PIAs. 4 things. Under GDPR, there are some cases when it's mandatory. So if you are doing something that is high risk, that is likely to impinge on people's rights and freedoms, or is new and novel technology. So if you are going to set up a new facial recognition system, you are required to do a PIA. You are also required to then consult impacted individuals over it. And you may, if your risk level, unmitigated, so without controls in place, is high, you are required to consult with the regulator on it. And some regulators, some of them, like the ICO in London, have a list of kinds of PIAs they want to be consulted on. In terms of your regulator, that is the country where you have most control or processing for your organisation in Europe. So a lot of New Zealand companies, that is the ICO in London. Some of them it's Ireland, but other companies it could be the Netherlands, etc. So you need to work out which of those regulators is your one. Some of them you are required to register with them. So you need to register your DPO, your representative with them. Most of them it's free, a few of them it's more like $50. But you need to find it and do that step for your company, either as a controller or a processor, or both. So you will then, for your PIA, consult with that regulator. That does not stop you consulting with the Privacy Commissioner here. But equally, if you consulted with the Privacy Commissioner here, that does not excuse you from consulting with Europe if you're meant to be doing it. So you might find you have a double consult model that you need to consider. So, in terms of breach, so one of the biggest things you would have heard from GDPR is mandatory breach reporting came in. So, this may or may not have gone as Europe planned. I'm suspecting the less so. So, in terms of breach reporting, the roles depend on what role you play within GDPR. So, if you are a processor and you have any kind of breach, however small, insignificant, of a data belonging to a controller, you are obligated to advise the controller as soon as reasonably possible. That in most controllers' cases means now, not next week, now. So you need to do that. You are not allowed to speak to anyone else about it. So most of them will have in their contracts, you will not make a public press statement, you will not tell anyone else about it. You will just tell the people whose data it is. So in terms of, that's what we're saying, if you are one of these organisations that has both controller and processor data, you need to know, before you have a breach, which is that split of that data. Am I the processor? Am I the controller of this data? So if you are the controller of the data and you have a breach, then you have a couple of tiered process. First of all, has it impacted absolutely nobody? In which case, you need to record it on your breach log. So you are required to have a breach log. And if at a later date the regulator wants it, the regulator can come and ask to see it. The other thing about that breach log is you're meant to learn from it. So if you keep having the same breach over and over and again, you are meant to have done something about it. So you've then impacted on people. You've actually had a net effect on them. So there is a requirement to advise your regulator in Europe. Again, doesn't stop you advising the Privacy Commissioner here. Good practice, they will help you, etc. But you are required to notify your regulator. If you have a choice of regulator, I would strongly suggest you go with Ireland at the moment. There is nothing like using Google Translate to try and explain to the Netherlands about your breach. It does not go well. So just think, if you have any way of choosing, go with the Ireland at the moment, and I'll explain why I'm not UK shortly. So in terms of that, you've got to have to notify them. Now, if you've had a likelihood or a real impact, significant impact on individuals, you are also required to notify them. And you have to take reasonable steps to get hold of them. So, it's really important, therefore, you have their contact details up to date. Because you do not want to be the company last week that had to publish in their national newspaper that they had a breach and they couldn't get hold of their customers. Newspaper helped them greatly with second page in. So, you know, real incentive for you to keep your contact details up to date for your customers. So, if you have a breach, the other thing is, if you go to the regulator and say, hey, I've decided that I don't think I want to notify people, it's not kind of the conversation you most likely want to have. So even if you have not notified individuals that you've had significant risk to, you at least, by the time you consult with that regulator, want to have a plan. Okay, so you might want to go there and say, I want your opinion on it, but you need to have had that plan ready. And you've got 72 hours from the incident to notify. And it doesn't care if it's Christmas Eve, etc. The 72 hours is from the minute you know you've got a problem to being at the regulator. Now, bear in mind, we have time zone issues. The regulator, therefore, would most likely prefer you speak to them in the daytime. So, you know, don't let your 72 hours clock right through till it's the middle of the night. We've had at least one customer who thought that was a good idea. So, rights under GDPR. So, I heard a lot about rights and right changes under GDPR. So, the New Zealand rights that you have now are unchanged, still apply. The other thing is that only the controller will enact your rights. So, if you're a processor and you get what's called a SAR, which is a subject access request, same as a privacy request, subject access request, and you are the processor, then you need to send it to the relevant controller. Do not answer it. You need to send it on. So they have the right to access. Again, same as New Zealand. The difference, though, is if you are a private enterprise under New Zealand law, you can charge for that right. Under GDPR, you cannot. So you need to know which legislation you're working under before you start getting out that bill. So you can access your information, exactly the same as New Zealand. You can ask to have it corrected. You also have a right to be informed. Now they've gone a bit further than New Zealand law, so you have to have a privacy notice, exactly the same, but it has to be understood by the layperson. Okay? So it needs not to be in legal special, it needs to be in English. So there have been some really great ones with infographics, with cartoons, etc. It also needs to be appropriate to your audience. So if you are targeting children with your service or whatever it is you're doing, it needs to be geared to the language they understand. Right to be forgotten. So it's one that has come up time and time again for New Zealand. So if you don't want me to hold on to your information, you can ask for me to delete you. That said, just as a controller, because you get one of those requests, do not delete everything you have got. If you have a legal obligation to keep it, like the customer's invoice that IR need for 7 years, it is not a good idea to go forth and delete that. IR will not take kindly to you on it. So think about, do I actually need to keep hold of some bits of the information? You need to delete what you don't need, but if you have a legal basis to keep it, please keep hold of it. So if you decided that you are not going to delete something when someone asks for it, they then have the right to ask you to restrict processing. So for example, if you kept hold of their invoice because you said to them, I need to keep it for tax purposes, then they can say, fine, but restrict my processing to only use my information in order to provide it to IRD if they ask for it. So they can actually lock it right down and say, no, only for what you told me you need to keep it for, are you using it? So you need to be super careful in that circumstance that you don't then start inadvertently using it for other things again because it's in your database somewhere. The right to decline automated decision processing. So this is the right for the computer not to decide your fate. So if you want, you can request that a human makes a determination for you. Doesn't mean you get a different answer. And where we usually see this is around things like credit checking. So you're not automated credit check, got an answer back, yes, no, likely to pay their bill. If it comes back and the business says, no, I want you to decide, then you have to manually go to Dun & Bradstreet, wherever it is you're going, and get them to do a manual determination. The answer is likely to be exactly the same, but they have that right. If you are using those algorithms to do automated, you need to declare that in your privacy notice too. So it needs to be there, apparent to individuals what's happening. An individual can object to you processing their information. Now they can only object on certain grounds. Those are if they are disagreeing with you about the accuracy of it, they can object to you using it until it's resolved. It's not indefinite, but while you resolve the issue. The same as if you and them are having a debate about a deletion request, they can object to you using it while you resolve that debate about it. So it's sort of like a sort of freeze on their records while you resolve your affairs. And then the last one, portability. So you can request a copy of your information to take with you, to go to your competitor, for example. So the person can ask for you to even send it direct to your competitor. So if you are an energy company, for example, they might say, I want my last year's usage so that I can go to your competitor to get a really good quote, and also so that they can put me on smooth pay because they know how much power I use. If you're a government department here, not much portability. Not quite sure where anyone's going. But if they want it and they think they're going somewhere, then why not give it to them? So, brings us on to Brexit. So what happens with London and the UK when Brexit goes through? So, if there is a no deal, what will happen to them is that the ICO in London, so the regulator, can no longer be a European regulator. So under GDPR, they are no longer a supervisory authority, which is their equivalent of a regulator. So you will need to find a new one if you're with the ICO now. So you will need to go look at, again, across Europe, find out where your next biggest country is, your processing location, and choose to go there. So you may want to give yourself time to introduce your affairs to your new regulator before the first communication you have with them is your breach. So go do your introductions ready. In terms of transfers to the UK, so if information under GDPR is transferring over an international boundary, it needs to be covered. So either it needs to be in the EU, or it needs to be going to what is called an adequate country. So New Zealand's an adequate country. So it can transfer over that border without additional controls. Or it's going to someone who's got privacy shield, it's the other common one. There are a few other exceptions, but those are the common ones. If there is a no deal, the UK does not have adequacy status. So they are treated like Australia is. They are deemed not to be a safe place as of a sort of God-given right. So if you are going to be transferring information to the UK, you need to have used what's called model clauses in your data processing agreement to have provided that additional legal certainty about what they're going to do with the information. So those companies that deal a lot with the UK at the moment, there is a lot of new processing agreements going round, getting them all signed. Because if you've got to do that with every one of your vendors, there's a whole huge pile of them for most companies. In terms of binding corporate rules, so binding corporate rules are ability within an internal company to be able to share information, usually globally, and they are a set of approved rules by a regulator. The ICO used to be able to approve them. Going forward, the ICO cannot approve binding corporate rules under GDPR. You will have to get another regulator to approve them. If they had approved them previously, they still stand, but they can't do any new ones. Also, a lot of New Zealanders have their representative in UK because they like to speak to them in English. If your representative is in the UK, they are no longer in Europe. So you will need to get a new one somewhere else. But before you fire your UK one, we will just think and just wait, because we'll come on to it. The other thing is breach reporting. So if you used to use the UK as your regulator and you were sending them your breach reports, you need to send them to your new regulator. So whoever that might be. So for some of you in the audience, the impact of Brexit might mean that you are actually no longer in scope of GDPR. If all of your customers you targeted were in the UK, you may no longer be in scope. So first, before you do anything, is actually think, am I still in scope of GDPR? Or has that actually removed that problem? Now, if there is a divorce agreement, we managed to finally get one, the only difference to the outcome is that there will be a grace period to move between the two circumstances. If there is no divorce agreement and there is a no deal, you will wake up one morning and it is so. So you need to have done that pre-planning and make sure you've got all the steps in place before you can't do stuff on the next day. Before you become non-compliant overnight. Now, before we all rush out and think, great, okay, I don't need my UK representative, I'm out of scope of GDPR, isn't this wonderful? The UK had prepared for this moment. So they copied GDPR into their primary ledge for their country, word for word, including the extraterritorial scope. So you may find you are no longer in scope of GDPR, but you are now in scope of what they call their Data Protection Act. And it has exactly the same things. But your representative for the UK now needs to be based in the UK. And your breach reporting needs to go to the UK. So you might actually find that your compliance burden has got worse. Because now you've got two representatives in Europe. One in Europe, one in the UK. You have two regulators to consult with, on top of what we have at home. So you might actually find you need to consult with, for your PIA, France, UK, and the Privacy Commissioner here. So you might actually find your compliance burden has got more. But for a lot of New Zealand companies, it's like they have discovered they're no longer in scope of GDPR. Because actually, the company they're targeting, or the individuals they're targeting, are in the UK only. So before you sort of panic and think about it, am I still actually in scope for it? So that just gives you a bit of background about what GDPR is. But in terms of it, again, the key message is, if you are doing best practice New Zealand, there is not far uplift to go. The noise was around things like third parties and about sub-processors. So under GDPR, you have to guarantee your third party is able to process sensibly and do what they're told to do. Again, under New Zealand law, you are responsible for your third parties. You do not throw their information over and walk away and hope they'll do it right. So it is no different. So what did happen was that a lot of third parties, a lot of controllers decided to check this level of compliance. So around sort of January, December last year, there were millions of spreadsheets of questions coming from controllers to processors in New Zealand asking about their compliance status. I think the worst one I saw had over 200 questions on it, about everything down to your inside leg measurement for a controller. So, you know, those spreadsheets are coming around trying to cover themselves to guarantee their processor. And the reason they're doing that is that both the controller can be fined for themselves and the processor individually can be fined for non-compliance too. And actually we've recently had a fine where the controller was found not to be at fault and the processor had lied to them, so the processor got fined. But the controller is liable for the fines of their processor if their processor does a disappearing act. So they are being really careful and making sure their processor is not going to pull them into disrepute along with them for it. But as I say, best practice New Zealand, you'll get 99% of the way there. So it is not a huge step up. Where companies where we've been working with have struggled for their GDPR compliance is if they are very non-compliant to New Zealand or barely making it. And then there is a long way to go. But that is not a bad thing. You should be compliant for New Zealand anyway. It's not optional, so you need to raise your bar regardless. Okay. So, any questions from you guys?
Hey Caroline, so you talked a little bit earlier about the triggers that actually make GDPR relevant to you as a business, and you had sort of 7 things or so around that. Do you just need to have any of those triggers and have the scale be sufficient, or are those mutually exclusive?
So you just, to be in scope, you just need to have hit any of those triggers. Scale is not an issue. Scale is only important when we talk about whether you need a data protection officer.
Gotcha.
So if you hit any one of those triggers, then that is enough to bring you in. So for some people, what can bring them in is as much as using Google AdWords and not ticking the relevant countries. So best way of resolving that, don't tick Europe under Google AdWords. Don't bring yourself in as a controller. You're not targeting them then. So, have a look. Think about which of those reasons did you bring yourself in. And then, do you want to be there? Do you actually want to do business with Europe in that way, or is it inadvertent that you're going there?
Are you saying that you have to be actively targeting people in Europe before it applies, or if I'm operating a website here in New Zealand and I offer something on the website which is mainly taken up by people in New Zealand, but there's 1 or 2 people in Europe, does it apply? Does GDPR apply?
So you have to be actively targeting them. So, or tracking their behaviour. So if your website, one common one we can see on websites is if you are collecting identifiable information, like you have got Google Analytics running and you are collecting the full IP address of everyone who visits, then you'll be tracking their behaviours.
That seems to be contrary to some of the views of lawyers in this country who say if you're offering into Europe, then you're caught by it. So
Then you're
caught by it, GDPR.
So if you are targeting is what the guidance is from the regulators, you have to be targeting them.
Targeting Europe.
Targeting Europe. So it is not enough to just have, as I say, a website where someone has come, Googled around, found it, come onto it. You have to have been doing something. So that might be you've got a UK domain name, etc. But if you're just sitting here, minding your own business,
With the website I haven't been on.
then no.
Okay, that's interesting.
No.
What about social media? I'm particularly thinking about Facebook and Twitter. So I admin some groups, and for some of the settings, I have to do all world for particular activities, events, etc. to show up.
Yep.
Now, I don't target Europe, but I don't know what Facebook and its lovely algorithms may be doing.
So that is you as a controller, though. You made that choice. You started that event. So you are the controller in that relationship.
Yeah.
Facebook is just doing what you ask them to do. So unfortunately, you will bring yourself in scope by just doing that. So that is why Facebook, for example, have made really clear changes to their settings to allow you to do things like exclude Europe. So they actually have worldwide excluding Europe as an option. So that you can
search for and take global choices. That's also an algorithm.
So it sort of becomes a typical one. And that's their business model, unfortunately. So it is about knowing and understanding some of those sort of things, what you're dealing with, as to whether you can or can't. The other thing to say is that if you are just fringe edge in, the regulators are not coming from Europe to admire what we're doing in New Zealand. Okay? They've got better things to do in Europe than come over here. So unless you are impinging on someone's rights or having a massive breach, etc., they are not going to be coming here for your compliance. So make a risk-based decision. You know, if it is really important to you that you comply with every law and you are sure you are complying with every law in New Zealand and everything else first, then maybe you want to go there. But if it is a real fringe thing, maybe the risk is actually, I will just do what's right, I will comply with requests, etc., and then I maybe might leave some of the other bits.
We've got a question from the app. In terms of coverage, what if someone is engaging with a non-European branch of a European company?
So as a processor or as an individual? It doesn't say. So if they're engaging as a processor, then it will be just shown in their contract. Does that controller want you to be GDPR compliant? And that quite often when you're dealing with branches is around them as a group. So for example, if they have their data flowing between all their branches in one shared system, they will often ask you to be GDPR compliant because they're not sure if you may get someone's data who is in scope. So some of those big multinationals have made the choice that just said, look, if you deal with any of our branches anywhere in the world, we will just ask all of our vendors to be compliant because it's easier for them to not think about, well, this system, this case, yes, no, maybe.
Sorry, coming off the back of that one, Caroline, I think you sort of almost answered this implicitly, but if I'm a processor and I have to be informed by a controller that I am a processor for the purpose of GDPR, I'm not meant to work that out for myself, so to speak. Good
practice would say you should try and work that out though. So a lot of processors actually contacted their customers and said, hey, proactively, we've got a data processing agreement, which is our rules of engagement between us, available. Do you want to sign one? And also, can you tell us if you're in scope? Much better that, then you know what scale of stuff you're looking at. The other reason some of our processors did that is that data processing agreement between the two parties is kind of like a contract about how you treat personal information. Most times the controller will give it to the processor and they will write their legal version of it. If you are a big processor, you might want to write your own bespoke version. So if you get there first, then you can share yours out. So for example, if you try and get Microsoft to change their data processing agreement, it's a long legal battle to which you're not going to win. Same for Xero. Xero have their one, it's like that. Unless you're a big ass customer, that's the one you're signing. Whereas if you had not front-footed that with here's my version, then you'll get everyone's bespoke version back.
Just another observation, Caroline. The right to be forgotten, the right to erasure, I find that enormously problematic, I must say, for people like Google, who have to make a call as to whether they should delete something or not. So they have to make a call as to how they distinguish between a Mark Lumley or a David Bain or a Scott Watson, say.
Yep.
So they have a huge amount of discretion to make that call, and then it might be available elsewhere in the world. So it's a futile exercise in a way. Do you have any comment about around?
So sometimes you're right. The right to be forgotten it is about best endeavours. If it's really obviously that you don't need it, getting rid of it. But if it's going to suddenly become available somewhere else, then how much effort do you go to?
Conviction in a court case, do you keep it up or take it down?
You need to make a call on for yourselves.
For you to decide that.
Yeah. And it's about having it documented. Exactly the same as stuff in New Zealand. I documented my thought process. Okay, if your thought process was a bit flawed, well, that's a discussion you and the regulator can have. But if you didn't have any thought process at all, then you were going to get a lot more criticism for it. So you can at least show, I thought about it, I did these actions because of this. Then that will set you up in good stead. The other thing is, if someone goes to the regulator and says, you didn't enact my rights correctly, then the first thing to do is then work with the regulator. Find out what it is they think you need to do and why you've made your decision, etc. They're not going to fine you for that very first non-compliance. They are there to help you to try and do it. If they tell you absolutely have to take it down, and you still point blank refuse, then absolutely, you can be the first person in Asia, in New Zealand, Australia, to get a GDPR fine, but don't suggest it.
Does Google attract a lot of requests for deletion?
Google has had loads of requests for deletion.
Yeah.
New Zealand itself has had lots of requests for deletion. Now, most of the requests for deletion is the most common request here in New Zealand under GDPR. Most of the requests for deletion should never have been, because if we had been applying good retention processes and getting rid of stuff when we finish needing it, there would be nothing to delete. But there have been a lot of companies who've got very large mailing lists, ex-customers from 15 years ago, etc., who you should have got rid of before this point.
I'm interested in shifting customer bases. So we were talking before about how it didn't, and just your customers, if they were in the UK, that brought you into scope, and then again, the points about targeting them. So say they're in New Zealand, and like we were saying before, like say someone from the UK comes to New Zealand, you have the interaction with them, and then that interaction continues, but they've shifted back to the UK. Like, what happens there?
So if they are in the UK, for example, they would have the rights under GDPR. So part of that is, we've got companies in New Zealand whose checks and balances say, when you change your address, if you change it to Europe, we say to you, no, we can no longer do business with you. Or we're then aware that customer has gone there and is in scope, if you've got the address stuff for them. So some companies here have decided the best way of dealing with GDPR is to put in their terms and conditions that if you're a customer of ours, you're not in Europe. Okay, I want to resolve the issue one way, I guess. Not sure it's the best business model, but it resolved it. So, it is about understanding that risk. If you know they went to Europe, that's one thing. If it's someone who's checking their power bill for Contact Energy who just happens to be backpacking around Europe, most probably be pragmatic. They're not you weren't intending to get them there. The key thing is, if they had been in Europe to begin with, were you targeting them there? If they incidentally drifted back, that's a bit different. But are you actually encouraging Europeans to come through? Oh. Okay. Thank you very much. So one thing I would say is that on our website, to help you, we've got handy infographics showing the the difference between GDPR and New Zealand, and for Privacy Week as well, there's one about the New Zealand principles as well for infographics. So they're free to download them for you if you want them, and it's just got a pictorial view of it.